doing what's best for children by refusing to hear from them on the subject, and other such nonsense. Recently, an attorney posed a question on a forum for fellow Utah family law attorneys. The question involved how to find out what the children's experiences have been with one of their parents. This parent, in this particular instance, was dealing with some personal demons. And the question was, what kind of contact should the children have with that parent? And how do we find out what that should be? I responded on the forum that if this isn't a scenario in which both the commissioner and the judge assigned to the case should be interviewing the children themselves, and on the record, so that those who hold the fates of these children in their hands have the best possible idea what is going through these children's mind at this time, what they have experienced, how they feel, what they desire, and whether those desires are in line with their best interests, then there is never an appropriate time for the court to interview children. And there are plenty of times when it's appropriate for courts to interview children. Who could gainsay that? Many tried and failed, though not through any flaw in their arguments. One attorney who responded to my suggestion commented that this would be the worst time for a judge or commissioner to interview the children, but did not explain why. This attorney claimed that a private guardian ad litem, also known as a PGAL or PGAL, a terrible sounding word, but now you know, they say a PGAL should be appointed and to interview the children instead. I asked for an explanation as to why, and further commented by asking what ostensibly makes judges and commissioners so innately bad at interviewing children, and what makes PGALs innately so good at it. I don't know where the myth of the angelic child whisperer PGAL type and the demonic couldn't interview a child effectively if his or her life depended on it judge dichotomy came from, but it's nonsense. Another attorney, like many who comment on the subject, commented that children should never be interviewed or even, quote, exposed to the legal system unless absolutely necessary, close quote, whatever that means, and without identifying a scenario in which it would be, quote, absolutely necessary. This attorney claimed that because minor children's brains are developing, that being interviewed by a judge or by a commissioner is, quote, incredibly damaging to the child, close quote. In response to that comment, I asked, where's the evidence? The response I got was similar to what everyone says to me in response to that same question. Something along the lines of, every single child development book ever created, academic case studies, non-profits that specialize in it, etc., advise against judges or lawyers interviewing children. This is false, which should come as no surprise when anyone speaks in those kinds of absolute terms. But it's still widely believed, or at least asserted to be believed, in the family law profession. Another response I often get is, commissioners and judges are not specifically educated or trained in this area of law as those who practice it daily are. But that argument erroneously presumes, one, that unless a judge, commissioner, or lawyer is, quote, specifically educated or trained, close quote, in how to talk to children about what they have experienced, how they feel, what they desire, and whether those desires are in line with their best interests, well, that judge or commissioner or lawyer will inexorably make a mess of interviewing the child. That's nonsense. And two, that those who are or are certified as specifically educated or trained in how to talk to children are incapable of being incompetent child interviews, just by virtue of their desire to do well and the training they get. When I responded with, well, if it's so obvious and the research so voluminous and overwhelming, please cite it, I got this in response. You can do the research yourself, and every single child development book, every single one ever created, academic case study, nonprofits that specialize in it, etc., all of them universally advise against judges or lawyers interviewing children under any set of circumstances. This is false, which again should come as no surprise when anyone speaks in those kinds of absolute terms. But again, it's widely believed or asserted as believed in the family law profession. Commissioners and judges are not specifically educated in this area of law as those who practice it daily are. Okay, but they do practice law with children all the time. They develop a feel for that anyway. And this training isn't that great. The argument erroneously presumes that unless the judges or commissioners are specifically educated in how to talk to children about what they've experienced and how they feel and what they desire, that somehow they don't know how to relate to being a child themselves, having their own children, or having to deal with the best interests of children in the course of their daily work as judges and commissioners dealing with these exact same kinds of problems. And where do we get the idea that just because somebody wants to be a PGAL, that person definitely can't make a mistake and will always act in the best interest of the children and cannot possibly be incompetent or even biased? Okay? So what I wondered is that if there's so much research on this, and if it's so obvious that this is such a terrible thing, why can't somebody give me some proof of that? Now, I'll be the first to tell you that I understand there would be situations, I've even encountered a few, where interviewing a child may be worse than not interviewing that particular child. It used to be accepted in America that tomatoes were poisonous to humans. Now, this is going somewhere, so bear with me. It wasn't until Robert Gibbon Johnson, no relation to me, ate a tomato on the courthouse steps of Salem, New Jersey in 1820 that he proved otherwise. Dispelling that myth has been a culinary and economic boom to the entire world. I just recently deposed a 14-year-old child in a parent-time dispute case. She was not only willing to testify, but was grateful for the opportunity to have her voice heard and her viewpoint considered. She was a particularly compelling and credible witness. The evidence she provided could not have come from any other source, and it couldn't have come from any better source, quite frankly. After her deposition, the case was resolved within a week. Her testimony was that compelling. The notion that any child testifying in any child custody or parent-time dispute case does terrible damage to any and every child is simply not true. And this is obvious. I know this because I have deposed children to the benefit of the child and truth seekers alike. Blanket prohibitions on child testimony, on the grounds that they are nothing but harmful to all children, are not only false, they are also contrary to fundamental concepts of fact-finding and subserving the best interest of the child himself or herself. I know that eliciting child testimony is not harmful to all children because I have real-world data and experience to the contrary. And not just someone else's claims, some study that I read, but my own experience. It has unfortunately become an article of faith in Utah family law practice that child testimony does more harm than good. That has not been my experience. And I challenge anyone to give me an experience to the contrary in a normal setting. I am one of the few attorneys in Utah who has this kind of experience. It is therefore hard for me to give unverified claims the same weight as my own experience and the experience of those children I deposed and the parents of those children. I would be lying if I asserted that child testimony inexorably and/or irreparably harms most, let alone all, children. Blanket prohibitions on child testimony are antithetical to fundamental principles of our legal system, such as diligent investigation, careful and impartial analysis, real respect for children's rights and best interests, and honest judgment.